He used his work discount for his wedding. They sued him for $47,000. It started as a dream wedding. It ended with a lawsuit for $47,000, filed by a man who never even made it to the altar. The plaintiff had worked as an event coordinator for a mid-sized catering company for nearly 6 years. He was good at his job, methodical, detail-oriented, the kind of person who color-coded spreadsheets for fun. In the spring of one particular year, he got engaged, and like most people who work in events, he decided to use the tools available to him, specifically his employee discount and the company's premium venue partnership program, a perk outlined clearly in the employee handbook. 20% off contracted venue services for any full-time staff member with more than 3 years of tenure. He booked a venue through his employer's partnership. He put down a $12,000 deposit. He sent out invitations. He ordered a cake. He hired a photographer. He bought a dress for his fiancée, or rather, she bought one and he reimbursed her. The date was set for the following October. Everything was in place. Then, in August, 8 weeks before the wedding, he was laid off. When the layoff came, it wasn't personal. The company cut 11 positions in a single afternoon as part of a broader restructuring. The plaintiff was given 2 weeks of severance and a handshake. But what he didn't receive was any clarification about what losing his job meant for the employee discount program or for the venue booking that was already contractually locked in under that discount. He assumed the booking would hold. It didn't. 3 days after his termination, the venue contacted him directly. Because the partnership discount was tied to active employment status, the original contract was now void. He could rebook at the standard rate, which would cost an additional $19,500, or cancel and forfeit the deposit. He tried to negotiate. He called HR. He emailed his former manager twice. Nobody responded. He canceled the wedding. His fiancée, according to testimony, was devastated but understanding. The relationship, however, did not survive the following year. By the time the case reached the courtroom, the engagement was off entirely. The plaintiff sued his former employer for $47,000, the deposit, the photographer's non-refundable retainer, the dress, ancillary vendor cancellation fees, and emotional damages. His argument was straightforward. The company never disclosed in writing that the employee discount would be immediately revoked upon separation. The handbook said the benefit was available to employees with 3+ years of tenure. It said nothing about termination clauses. The defense was equally composed. The company's attorney argued that any reasonable person should understand that employee benefits end when employment ends. They produced the standard onboarding packet, which included a single line, buried on page 14, stating that all employee benefits were contingent upon active employment status. They also argued that the plaintiff had been verbally informed of this policy during his exit interview. For a moment, the defense had the room. It was a coherent position. Employment benefits end at termination. That's how employment works. But then came the exit interview recording. The plaintiff's attorney had subpoenaed the company's HR documentation, standard procedure. What came back was a 40-minute audio recording of the exit interview, which the company routinely recorded for internal quality purposes, a fact noted in the employee's original onboarding documents. The recording confirmed that during the exit interview, the HR representative had told the plaintiff verbatim that his benefits and vendor partnerships would remain active through the end of the current calendar quarter as part of his separation agreement. The company's own HR department had told him out loud that the venue booking was safe. Nobody in legal had been informed. The HR representative had misspoken, but she had said it clearly, on record, 8 weeks before a wedding that never happened. The judge ruled in favor of the plaintiff, but not for $47,000. Emotional damages were dismissed as too speculative. The dress was excluded as a third-party expense. What remained was concrete, the $12,000 deposit, the $3,800 photographer retainer, and $1,200 in vendor cancellation fees. The judge awarded the plaintiff $17,000, citing promissory estoppel. The plaintiff had reasonably relied on an explicit verbal assurance made by an authorized company representative, and he had suffered direct financial harm as a result. The company's restructuring saved them 11 salaries. The lawsuit cost them $17,000 and, reportedly, a complete overhaul of their HR separation protocols. The plaintiff used the settlement to take a trip abroad. He went alone. The recording changed everything, but it also raised something the verdict couldn't quite resolve. The HR representative hadn't lied. She had simply made a mistake. The kind of small, well-intentioned error that happens in bureaucracies every single day. So the question the case leaves behind isn't really about contract law, it's this. When a company's carelessness costs someone not just their money, but the life they were building, is $17,000 actually justice? Or is it just the closest thing to it the law can offer?